Are you divorced? Is your ex-spouse supposed to pay maintenance but has defaulted on payments? Hi, I'm Simon Dippenaar and I'm a family lawyer. A requirement to pay maintenance is often included in a divorce agreement. This would be spousal maintenance, child maintenance, or both. There is not always a court order involved, but if there is one in place, it is legally binding. In maintenance disputes, a court order can be a critical tool to safeguard the emotional and financial well-being of vulnerable parties, usually women and children. Disregarding a court order can have severe consequences, which could even lead to imprisonment. The non-payer can be found in contempt of court. This occurs when an individual deliberately and willfully disobeys an order of court. Contempt carries the same burden of proof as criminal matters, requiring proof of willful and bad faith non-compliance. Where maintenance required by a court order is not fully paid, you can file a contempt of court application to recover the amount you are owed. You must prove the non-compliance was intentional and not a result of genuine change in your ex-partner's financial circumstances. The courts prioritize the protection of the rights of vulnerable parties, particularly children who rely on maintenance for their basic needs. A court order is not optional or conditional. Obedience to court orders upholds the legal system's integrity. For women and children, a court order is a tool that ensures financial support. When the payer does not comply, severe penalties can be used to compel compliance. You are entitled to approach the court to enforce full payment to provide for your family, but for an application for contempt of court to succeed, willful and bad faith non-compliance must be proven. Keep records of non-compliance, such as short payments, failure to cover agreed expenses, and missed payments. Proof of financial hardship, such as unpaid school fees and bank statements, strengthen your case. If your ex applies to vary the court order, claiming a change in financial circumstances, the court will normally order compliance with the existing order before an application for variation can be considered. This principle is based on the need to maintain the authority of court orders and prevent abuse of the court process through the use of an application for variation to avoid or delay complying with a court order. The court is unlikely to consider a variation application until the non-compliance is rectified. A child's access to basic needs such as housing, education, and healthcare is a constitutional right. Section 9 of the Children's Act ensures that the best interests of the child guide the courts. Therefore, the courts prioritize the needs of the children in maintenance disputes. When non-compliance directly affects a child's access to basic needs or stability, we highlight this impact in court applications. As with all matters in divorce and co-parenting, open communication can prevent disputes escalating. Interactions between you and your ex should be documented. Where your ex-partner claims hardship, you can request evidence swiftly and start discussions regarding reasonable adjustments promptly. The alternative is uncertainty and financial strain, affecting the fulfillment of children's basic needs. Where a court orders a punitive measure for non-compliant parents, this may be suspended provided the outstanding amounts are paid within 60 days. Harsh consequences serve to provoke adherence to the court order rather than punish the defaulting party. An opportunity to rectify non-compliance balances the need to uphold the legal integrity of court orders with the needs of the children and acknowledges practical considerations. Contempt applications can encourage payment of arrears in a manner that does not result in imprisonment, which could negatively affect the ability to provide financial support. However, the option of a more severe punishment exists where the order is still not respected. The court's aim is to protect the vulnerable party's interests and encourage compliance. Our judicial system takes the court's role as the upper guardian of children seriously by enforcing court orders that ensure children's basic needs are met. If your ex has defaulted on maintenance payments mandated by a court order, I can ensure your rights are protected and your child's best interests are put first. My firm, ST Law, has deep experience of divorce, custody, and maintenance. If you have concerns over your maintenance agreement or problems with maintenance arrears, get in touch with me on the number below for a confidential discussion.